All those having business before the court draw near, you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is the 6th day of April. I'm Judge Capper, and we are first going to do reviews for people who are working on completing their court order. So if you're here for that and you don't get called, I think you should have, you have to go check in with the clerk. If you missed a hearing before, you're not automatically going to be on the docket. You got to go check in. You won't be called reviews.
Caitlin Allman, Devin Kahn, Joseph Graham, Lisa Jackson, Levi Jones, Vicky Scarberry.
Caitlin Allman, 25,500. Caitlin Allman is not here. Did her community service but hasn't paid her fine, so it will be a warrant issued for failure here. Devon Kahn, 25,1903. You pay all your fines off. You still have your community service and the driver intervention program.
I've finished my driver intervention program. I have a certificate right here, and I just turned it in to probation.
Your Honor, I believe it got entered today.
Okay, you didn't follow anything? Do we already have, we need a copy of that to put in the file if it's not already in there. I don't see it's
I
on
think you
file.
made a copy this morning.
Huh.
I think you made a copy this morning.
Yeah, I believe Mr. Major made a copy this morning.
Okay.
Scanned it.
All right, what about your community service?
I was actually ran over by a car 5 days later after being told what to do. I got all the forms from the doctors and x-rays, anything you needed to see. I had spinal surgery, fusion surgery. I broke my spine in my neck. I was hit by an intoxicated driver 5 days
Well,
after.
I'm sorry to hear that. I'll give you some more time. Are you still getting treated, or?
I am currently. I'm in physical therapy for the next 6 months.
I didn't hear that.
I'm in physical therapy for the next 6 months.
Okay. Well, I'll give you some time. Let's come back. And where do you live?
I live in Whartland, Kentucky.
Okay. I'll set you in July for your next hearing.
July?
Yeah.
What time July?
Mondays or Fridays?
What date would be? Because I have court in Greenup on the 22nd.
Yeah, what?
I have court in Kentucky on the 22nd.
Okay, that's a Wednesday. So
Okay.
I'm looking at the calendar right now. We always have court on Mondays and Fridays, so
Okay.
does it matter which
A
day?
Friday would work best.
Okay, I'll set it for the 24th.
Okay.
July 24th will be your next hearing here for review, so I'll give you some time to heal up,
Okay.
and then you get your community service done, because otherwise you gotta do 20 days in jail. I assume you don't wanna do
I
that.
don't know.
Okay, you'd rather do the community service. All right, good luck on your recovery. We'll see you, write this down, so you'll have the date, July 24th at 9 a.m. is your next hearing. Joseph Graham, 26-2. Lawrence County Recovery, and I've got a written report from them. Okay, it's a good report. It says you're still got stuff you're working on, but you're compliant with your meetings and so forth, so that's good. You have community service to do also?
Yes, I still have 4 days, Your Honor. Where I was at in focus recovery, I had no free time. They had me going 3 days a week, and that was the only days I had off the week. When I switched to Lawrence County Recovery, I should be able to get those finished this month.
Okay. What about your fine? Can you pay anything on your fine today?
This Thursday I'll be able to put another 100 on it.
Okay, I'm going to set your next hearing in May, so you are working
Yes, sir.
Mondays or Fridays. What's the best day for you to come?
Either or, it don't matter. I have a rotating schedule.
All right, let's look. I'm going to make it May the 18th. May the 18th is a Monday. It'll be at 9 a.m. on May the 18th. Once you get everything done, you can come to the hearings.
Yes, sir.
Lisa Jackson, 2017-31. Lisa Jackson's not here. And she still has a lot of work to do, so there'll be a warrant for failure to appear today. Levi Jones, 25-3-23.
Is that in this paper?
And he's at RRS, got a report. Says you're compliant and your screens are good. Okay, so a good report. I'm showing you got 1 day of community service left.
Yeah, I'm gonna do that in the morning. I'm gonna finish it out.
Tomorrow morning?
Yes, sir.
Okay. What about your fine? Can you pay anything on that?
Yeah, I'll put down like 100 next week.
Okay. If you can't pay, you can do extra community service to take.
Yeah, I'm gonna do extra community service just to get it, like half of it paid off through the community service. I'm gonna pay the rest off.
Okay. Mondays or Fridays, does it matter for your schedule?
Mondays, I prefer Mondays.
May 18th is your next hearing. 9 o'clock. That is a Monday. Continue with your counseling. Get everything else done too, so we wrap this up.
Thank you, sir.
You're welcome. Vicki Scarberry, 24-12-72. She's done very little on her case, and she hasn't appeared today, so we'll need a warrant for failure to appear.
Your Honor, if I may, she was not a community services related.
Thank you.
Otis Sexton, Stacy Crockett, Jason Taylor II, David Vance, Sarah Woods.
Otis Sexton. You're Otis?
No, I'm not.
Okay. Otis Sexton is 24-5-39, 24-7-70, 25-39 has not appeared. There'll be warrants on each case issued for failure. Stacy Tackett is here, 22-475. She's at Bethesda. Okay, it's a good report, says you're compliant, but you're still working on things. How do you feel about it?
You did.
Good? Okay. All right. At this point, your sobriety is the most important thing, so I'm okay with that, but you also have some community service and fines to pay. So whenever she can get some time to do community service, that would be good to get that, some hours in. I'll set you for May the 8th. That's a Friday, May the 8th, 9 o'clock. Okay,
Thank you.
good job. Jason Taylor. Case numbers are 17-22-66 and 25-24. Okay, what we're dealing with is just money, fines and court costs that have to be paid. Can you
So
make
today I have $10, but Friday when I get paid, I'm gonna come back and pay $100 on it.
Okay, see the clerk to make your payment. Monday or Fridays for your hearing.
I'm sorry, what is
Mondays or Fridays.
Mondays, I'm off on Mondays.
Okay, we'll make it May 4th.
Okay.
May the 4th is your next hearing, 9 o'clock. See the clerk to make your payment.
Thank you.
Good luck. David Vance,
Yes, Your Honor.
case number 24-1921, 24-597, 25-50. All right, not a whole lot's happened on this. We got to get this case moving.
Yes, Your Honor. After the last time I was here in February, just a few days later, on the 14th, I was thrown into an emergency gallbladder surgery. I ended up with 18 staples across my midsection and my lower stomach. My recovery time for that was 8 weeks. That actually ends on the 11th. I just made a $20 payment the other day, and as soon as, I think it's Saturday is the 11th, that's the end of my recovery period, I can get down here and start doing the community service.
Okay, so give me a date that you're going to be here for community service.
If Saturday's the 11th, Sunday, Monday, I can be here the 14th, or the 13th, I'm sorry, on that Monday.
Okay. All right, Mr. Cooper will be looking for you then. I'll set your next hearing. And are you back working?
No, I'm putting in
Will you be working
application.
after that, or?
I do plan on it. I've been putting in applications the last 2 weeks
You
in
don't have anything
preparation.
definite then?
I had actually been recovering from a surgery last year on my wrist, and by the time I got cleared to go back from that, I ended up having another one.
Okay, I'll set it for May the 8th, is your next hearing. That's a Friday. May the 8th,
Thank you, Your Honor.
9 o'clock. Sarah Woods, 22-326, 21-686, and she's been called and hasn't appeared, so there'll be a warrant for failure to appear.
State of Ohio recalls Lisa Jackson, case number TRD 2017-31.
Okay, Lisa Jackson is here now, was called earlier, wasn't here. Okay, Ms. Jackson, you got 3 days community service and fines to pay. Tell me what you're going to do to take care of this.
I have 2 more days of my community service. I've been in the hospital. My heart rate has like been sky high. That's why I was like this morning I was getting this thing and all these machines hooked up to me for like 48 hours. Friday I'll be making another payment.
Okay. Well, if you can't do community service, you need to bring me some medical on that, okay?
Okay, that's fine.
Next hearing will be May the 8th,
May the 8th, okay.
9 o'clock. By medical, I mean medical records or.
Records, okay.
letters, something like that.
How much do the rest of I owe on my fines it shows?
210.
210 left, okay. Thank you.
Okay, you're welcome. Okay, we're going to start the arraignments now. That's the new cases. And if you're here for a new case, when your name's called, come up to the table to your right, stand there. I'll tell you what the charges are. They may not be true, but you need to understand what the state's alleging against you. You don't have to say anything. You have a right to remain silent. But if you do make statements, we're in open court. Everything in the courtroom is being recorded visually. So there's video and audio. There'll be a video and audio of you saying whatever it is you say. So if you get up, a lot of times people omit stuff on the record about their case, and if you do that, you're stuck with it later. It's hard to withdraw that later and say, I said brown, but I really meant white, so whatever. Just as an example. So it's not the trial today, so I'm not going to say, oh, you're right, I'm throwing your case out. So that's not happening. So don't get up here and tell me a bunch of facts or what you think the facts are. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio prove the charge or charges they filed against you beyond a reasonable doubt. You give up those rights by entering a guilty plea or a no contest plea. Don't enter those pleas if you don't understand what's happening, if you're confused, if you don't know what to do, if you want a lawyer, if you want a trial. Enter a not guilty plea. That's always the safest plea. Don't enter guilty or no contest because you want to get it over. That's not a good reason to enter one of those pleas. Call the first case.
State of Ohio versus Gavin Harris, case number TRC 26550, A and B.
All right, you're Gavin Harris, and I believe this is Mr. Delauder's case. He said he was going to have to stand up, so meet him in the courtroom.
Yes.
I'm sorry, Judge, I didn't hear you call that one.
Okay. Yeah, this is Mr. Harris's arraignment. Do you wish me to read the charges?
Your Honor, I've gone over the charges with Mr. Harris. He's aware of the charges. Now, the ones I knew of were a OVUAC charge and a window tint
That's correct.
ticket.
That's what's filed.
And I've talked to Mr. Heald about this case, and it's my understanding that Mr. Harris is going to enter guilty pleas to those charges. And as part of the recommended sentence, I believe the state's asking for the court to order anything confiscated as a result of this investigation forfeited.
Yeah, I see on the bond form there was anticipation there was going to be an F4 concealed handgun charge filed. That's what the bond was set for, but that charge has not been filed.
That's correct.
And Your Honor, we made that decision just based on the circumstances and the fact that this young man was willing to come forth and enter a plea today to the other charge.
Okay. So, Mr. Harris, your attorney's telling me you wish to enter a guilty plea to operating a vehicle after consuming alcohol underage and a window tint violation. Is that correct, sir?
Yes, Your Honor.
Okay. You have a right to make a statement to the court if you want. Do you have anything you want to say?
No, thank you, Your Honor.
Okay. All right, so as a part of this, is my understanding, the state's agreed to forbear following far more serious charge. Improper handling is a more serious charge than either of these two charges. But the state's doing that with the understanding he's going to forfeit the weapon that was in the vehicle.
That's correct.
We have a description of that. I need a description for the judgment entry.
I do. The prosecutor's office does have a description of that weapon. I
Does he
don't
know
have
what
it.
it is? I mean, can you give me a
Describe his
description?
name?
It's a Smith & Wesson Shield 9.
Will there be a serial number in the?
Well, yes, I would say we have one if it's, what's this young man's name?
Harris.
Harris. Okay. Your Honor, I don't have a better description of it than that in this file.
Is this in the possession of the State Highway Patrol then?
It is.
Okay, well, we'll try for that. Let's do the sentencing, and I'll put it in the judgment entry. I'll impose a $50 fine. Court costs be paid. This is on the operating vehicle. Make it 10 days in jail, suspended. on the condition that he has 18 hours of community service, that's 3 days. 2 years of probation, which will terminate once he's finished everything. There is a mandatory 90-day license suspension.
Yes, I've talked to him about that, Judge.
So there'll be a 90-day license suspension starting the date of the incident. You can't have driving privileges until 60 days out, so if he wants that, he can come back and ask for it. But you only have 30 days left of the suspension. Yeah.
And Judge, I don't know if you ever consider this or not, and I'm not sure you're aware, I did talk to Mr. Hill about it. Mr. Harris is in the Army National Guard, so he does a weekend a month with them and then 2 weeks a year. I don't know if you ever let that stand in the place of community service or not, but he works full-time and he has his National Guard obligations.
I never have done that.
Okay.
Okay, so the weapon will be ordered forfeited and destroyed. And then on the window tint, is it still on the vehicle?
Yes.
Okay, I'm going to order it removed. I'll do a $100 fine on the window tint and suspend 90 if he gets it removed.
Okay. She'll prove that to probation once that happens.
Yes. And 2 years level 5 probation. You'll need to meet with Mr. Major today.
I'll take him now.
And we'll set a review hearing for him October 5th. Should get everything done. If you get it all done, you don't have to come to a review hearing. That's just a hearing to make sure people are accountable and do what they're ordered to do.
You hear that?
So just confirm that you finished everything with probation, and you don't have to show up for that hearing. And you'll make sure he gets to probation.
I'll take him now.
Yes.
Thank you, Your Honor.
You're welcome.
Your Honor, I'm sorry, is the TRC, the airport, that's still considered the DUI-1?
I'm sorry?
Is that still considered the DUI-1?
No. This should be, you have rights in import.
Oh, it is everything.
Yeah, it is.
State of Ohio versus Alexis Russell, case number TRC 26546, A and B.
And ma'am, are you Alexis Russell?
Yes.
Ms. Russell, it's alleged that on April 3rd, not August, April 3rd, at 3:04 a.m. in Fayette Township, you were operating a vehicle while you were under the influence of alcohol or drugs, or a combination of those things. And it's alleged this is your first time you've been charged with this offense.
Yeah.
On a first offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most the court can impose as a penalty if you're found guilty. There is a minimum, so the least you can get if you're found guilty is 3 days in a treatment program, $375 fine, and 6-month license suspension. You understand that charge? And you're also charged with driving your vehicle at a speed that wouldn't let you stop and ensure clear distance ahead. Usually it means there's an accident. So, that's a minor misdemeanor. Maximum penalty is $150 fine for that. There's no jail time on that charge. Do you understand the two charges?
Yes, sir.
Do you understand the rights I explained defendants have? How do you wish to plead?
I don't really know what to do.
Not guilty then, if you don't know what to
Okay.
do, that's the safest plea. to enter.
Not guilty.
You want to be considered for a court-appointed lawyer?
Yeah.
Do you work?
Uh-huh.
What do you do?
I work at King's Daughters. I'm a tech.
Are you paid by the hour?
Yes.
How much per hour?
I think it's 17.
Okay. Do you have any dependents? Anybody dependent on you for income?
No.
How many hours a week are you working?
72.
72?
Mm-hmm.
Wow. Okay, that's a lot of, is that an hour, a week, or a pay period?
Pay period.
Pay period. Is that every 2 weeks you get paid? Okay. I have to determine, and I'm not being nosy, but I have a guideline. I have to determine your gross annual income. So I'm going to do a little math, and then it depends on how many dependents you have, how much you can make and still get a court-appointed lawyer. You can only get a court-appointed lawyer if you're what is called indigent, unable to pay. So I'm getting that you're making about $35,000 to $4,000 a year gross.
So I'm PRN, so I pick up week to week, so my hours just depend on how much I pick up during the pay period.
Okay.
So it's not always 72 hours per pay period.
Well,
That
do you
was
file
just-
an income tax return? Because I have to determine your gross annual.
Yeah, I did my taxes. I think
How much do you make, your gross income in a year?
I have no clue.
Well, if you're working full-time, you're making 17,000.
I'm not working, it's not, I don't work full-time.
Okay. How many hours in an average week do you work?
Probably like 60, around that.
How many?
Like 60.
In a pay period you're talking
Yeah.
about? So that's, so that's 1,500 a year, so 1,500 hours a year. So that would put you at 26,000 gross per year. Okay, so I'll go ahead and appoint Mr. Holt to represent you. Enter a not guilty plea. And he's here, so we're going to try to get him in the courtroom. So,
Morning, Your Honor.
good morning. This is Ms. Russell. She has ODI. I don't see a test. I don't know what happened with that, but there was an accident, it looks like.
There wasn't an accident.
Okay. She started with a sure clear distance ahead, that's why I said it. She can sign an OR bond of $1,000. Not guilty plea is entered for her. And as far as pre-trials go, let's look and see what we're doing. Could do the 27th of April or after.
Next time I'll be here will be May 8th, Your Honor.
That's fine. So May the 8th will be the next hearing. Pre-trial at 10 o'clock. She will need to go get fingerprinted at the jail. Mr. Cooper will give her the form to take to the jail for fingerprinting.
Don't leave on me, Jim. I'll give you a copy of this, tell you what you need to do. I'll get a copy of your file. Okay. What is it? I'll get a copy of your file. So wait for me on the lobby. Thank you, Your Honor.
You're welcome.
What is it?
State of Ohio versus Ronnie Gillespie, case number CRB 24601.
And sir, you're Ronnie Gillespie?
Yes, sir.
Okay, you had a review on Friday and you weren't here, is that right?
Yes, sir.
You have an explanation for that?
Sir, I got the days mixed up.
Okay.
I tried to call in here, but I guess it was too late before. So I called first thing this morning.
All right, well, that's good. You're in quickly, and you did graduate recently. Lawrence County Recovery's program, got a certificate of that in the file. Community service is all done. You've done some extra toward your fine. Don't have that much left to do. I'm showing $150 is all you got left.
I paid $20 this morning too.
Okay, that is in the file. So no warrant's been issued, no warrant will be issued on your case, and I'll just give you another review hearing.
Okay, thank you,
If you
sir.
get paid by the time of the next hearing, you won't have to come back. You'll have everything done. Let's make it May the 18th.
May the 18th?
Yes, sir. 9 o'clock, May the 18th. That's a Monday.
Thank you very much, sir.
You're welcome.
State of Ohio versus Taylor Bailey, case number CRB 17706.
Hey, ma'am, are you Taylor Bailey?
Yes, sir.
Okay, this looks like an older case that you had a review hearing back October 23rd of 20, and you failed to appear and there's been a warrant outstanding for over 5 years now.
Yes.
So, did you get arrested on the warrant, or are you coming in on your own?
No, I'm coming in on my own.
Okay. Well, tell me what's been going on the last 5 years.
Well, I've been clean for a year and a half. I have my drug screens and a letter from my treatment center, and this is the last thing that's holding over my head. I go to court to get my kids back the 21st, so.
Okay, well, let me take a look at what you got. Where is the court on your?
In Gallipolis.
Okay, yeah, you can. Is that where you're living now?
Yes.
Started in October 24, it looks like. Was that court order, or you went on your own?
No, I went on my own.
So the court you're going to is like domestic relations or?
Family court, yeah.
Family court. How old are your kids?
They are 11 and 6.
They in relative placement?
Yeah.
Okay. I'll withdraw the warrant since you've appeared. It looks like you have finished treatment, and the last entry was you needed to show proof that you were in recovery, which you have done. So you just need to pay your fines.
I can pay the rest of them off today.
Pay it off today?
Yeah.
Okay, so what I'm going to do, I'm still going to give you a hearing date because I've learned over the years that sometimes people lie to me in court.
I got you.
It's happened, where I say, okay, you're done, go see the clerk and pay it, and then they walk out the door and never pay a nickel.
I got you.
So this way I will catch it if you do that. So I'll give you a review hearing date, May the 8th. It'll come up. If you pay everything off, you don't have to be here. If you haven't paid, then you got to be here and explain why you didn't get it paid off. May the 8th at 9 a.m. is your next hearing. See the clerk today and pay it, and you'll be done.
All right, thank you.
You're welcome.
State of Ohio versus Jared Stover, case number CRA 2619, CRB 2620, CRB 25501, CRB 24461. This is Mr. Smith's case. And clerk's report is they asked for him to appear on a motion for a change of service provider.
All All right, we need Mr. Smith, is he here?
Sir, may I approach?
Yes.
Okay. I'm supposed to be reading. Gone off the rails.
And so he's completing an inpatient program at Focus, and as soon as more convenient in terms of location, we're going to go to RS for outpatient.
His job, he works daytime, and he has a home, he has a job, he has a car. He's been stable, he has a sponsor. So RRS have already accepted him upon your approval, and he'll be able to attend evening groups, and that will work with his
Okay.
current work schedule.
Any objection to that?
No, Your Honor.
Now,
Sounds good.
are these all the cases? He still has some that are pending? This is all of it?
Yeah.
I think it's all, I
Yes.
didn't bring his file, but I'm pretty sure we wrapped everything up a couple through a month ago, maybe.
March 16th, looks like one
Yeah.
of the entries in here is March 16th. Okay,
It sounds
so
right.
I'll approve, we'll need an order, there's a lot of different case numbers here, so, I'll need an order approving him to go to RRS for outpatient treatment. He has a review hearing that's set for April 24th, let's just keep that on. So we'll get a report then from RRS how things are going. Okay.
He
Thank you,
doesn't
Judge.
complete with us until Wednesday.
Okay.
So he
When
won't
he's
be,
completed, then
he
you
won't
can-
be leaving to go to their assessment until Friday.
Okay, that's fine. Finish your inpatient, and then you can start outpatient at RRS.
Thank you,
Come back here on the 24th.
Thank you, Your Honor.
Thank you.
You're welcome.
Your Honor, that's all the witnesses we have for right now. We're going to start some pre-trials.
Okay, we're going to start pre-trial, so we need the lawyers and prosecutor.
State of Ohio versus Cherie Bryant, case number CRB 2645.
Mr. DeWater's case for pre-trial.
Judge, this one, we do not have this resolved. I have talked with Mr. Hill this morning about some possible resolutions. But what we'd like to do, instead of setting this for trial, if we could have one more pretrial and have the complaining party here to consult.
I'll send this.
You just grab his laptop, you'll be right back.
Okay. All right, Mr. Hill, in this case, the defense is requesting another pretrial with the complaining parties present. Is that agreeable? Cherie Bryant.
Yeah, we can arrange that, Your Honor.
Okay, how much time do we need to, well, we have pretty jammed up in April, to the 27th is really the only open date in April unless there's a major time problem.
Is May, how about May 11th?
May 11th is on court, okay with the city.
Yes, Your Honor.
Okay, next hearing, May the 11th, and complaining party should be here.
Thank you, Your Honor.
That'll be a count.
Cherie, May 11th. Yes.
State of Ohio versus Lewis Martin, case number CRB 25582.
Judge, this is one.
Waters, case, and my next one is the complaining party of Western Beach.
Yes, we resent this today to see if the other party would be here, and I don't know if they are.
That's,
Robert
Shannon.
Rutherford.
Robert Rutherford, there was a precedent issued.
Sir, you can just come right here by Mr. You can just stand right here by Mr. Hill and he'll talk to you. Right there, sir. Yes.
His, at one time, I went over to my brother's house, and his mother's house over there, called the sheriff, and he said I was blocking access to the swamp, and there was no one trying to get in the swamp, and she actually blocked me, kept me from freedom of movement to try to get out the driveway. She stood in my car till the sheriff came.
Is that the same place that the other incident happened?
Yes.
How's your brother?
He stood there. That's the law. I don't really want him to do any justice. I just want him to know. And I ain't bothered him. The only thing I do, I go to my brothers and do a little bit of peace class. Sometimes I help him on the yard work and stuff. And do stuff around the yard outside there. I don't live there. And he's been jumping on me about all the stuff that's in there. It's not my property. They call me
Is that the problem?
No, what happened was 50-some years ago, me and my brother built a driveway, okay? Well, the driveway is now called First Avenue in Burlington. And at the end of the dead-end street is where my brother lives. So I go back to the end of the dead-end street. That's the only thing I do. And he tells me I'm not allowed to go back there.
I see.
After I've been going back there 50 years.
Okay.
So if he just leaves me alone, it will be fine.
The only problem is this, what he is saying, is can't guarantee what's going to happen.
Right, I know that.
But we can always file a new charge. It's again.
Okay, that would be fine with me.
All right. Well, let's,
Look, the only thing if he would have come and asked me if they could have parked in the driveway that night, nothing would have happened. He wouldn't have said nothing to me, I wouldn't have said nothing to him, okay? I would have told him he could have parked in the driveway if he wanted to, but he didn't ask me.
okay. Well, let's see if it's possible to resolve this.
Okay. Yeah, I know he's a working man and he has a family and stuff, but you know, as long as he keeps his hands to himself, I don't care. That's all I care about. I just don't want to be picked on because I'm 70 years old and he's 40.
Hey, Chris. Can he promise that he's not going to bother this man? Yeah. So, Your Honor, Mr. Rutherford's here, and he's the alleged victim in this matter. And Mr. Rutherford's brother lives on adjacent property to Mr. Martin. And so Mr. Rutherford comes to his brother's property very frequently. As a matter of fact, has for years and years, 50 years or more. And there's a little bit of a dispute about a common driveway. I can't exactly tell you exactly what the situation is, but on one occasion, there was just an interaction that was inappropriate in our estimation. But Mr. Rutherford says all he wants is to not have any more problems. So I think that, and I don't know if there's not enough room for everybody's vehicles in this right of way or what exactly goes on there, but if we can just have peace for another 90 days, we'd be okay with dismissing the charges.
Yeah, I agree. I've talked to my client about that. He is, I think what Mr. Hill's suggesting is that we continue this for about 90 days, and that's understandable and acceptable. If there is some sort of property dispute, there's a different court that needs to be dealing with that and needs to be done in a civil manner.
Yes, good luck with that. Property line disputes, or people get territorial and get upset, and then it gets expensive to litigate that, because you have to hire a surveyor both sides and do a bunch of research on the file, and even find, all the surveyors are dead and all. No, if anybody out there wants to get a job, go get trained as a surveyor, you can make tons of money, because there's nobody doing it anymore. No young people want to be surveyors, and there's just a handful left, and they charge you out the wazoo because they can, because they're covered up. They can't do work that people want them to do. So there's some free information you didn't necessarily need. So what's going to happen here is we're going to go 90 days, if nothing else happens and everybody's quiet and happy, charge will get dismissed. That's agreeable with everyone, right?
Yes, sir.
Okay, so let's look. That's in July. Let's set it for July 6th.
Yes, that's fine.
And no appearance required if there's no further problems. So
Thank you.
doesn't have to appear. If there are problems, then you need to let the prosecutor know that. So,
Thank you.
all right, July 6th, 10 o'clock, next hearing. Will be dismissed, and if there's no further problems.
And Mr. Rutherford wants to shake Mr. Martin's hand if he wants to do it.
Yes, sir.
Okay. All right. Good luck to you.
That's a hard squeeze, man.
Thank you, Your Honor.
I know where you're going to you all done with me, sir?
Yes, thank you.
State of Ohio versus Ricky May, case number CRB 25711.
This is Mr. DeWaters' case. My notes on this for today was set in trial date, and there's not some sort of resolution.
Yes, sir, and I believe we do have a resolution reached at this point. However, the state's proposal requires some things to happen before the case can get resolved. So I believe the request is that this be set on May 11th. That should allow plenty of time for the rest of the matters to be wrapped up so that we can, and just so you know, this case will result in a dismissal of the charge. But there are some things that the state wants to have happen in between, and that's fine.
So should we set it as a trial for May the 11th, or go ahead and set another pretrial?
I don't see the need to set it for trial because that would inconvenience the complaining party and everyone else.
Yeah, we're going to have the victim here on May 11th. I think things can be hashed out then at that time.
All right, May the 11th for another pretrial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Wait a minute, hey, Chris.
Yes, sir.
Were we going to, is he going to agree to do it? All right. Well, okay. All right. Should we put that on the record now?
Yeah, we can. Your Honor, on this May matter, part of the things that are going to be done in the meantime, we think, is that if the complaining party would like to try to obtain a protective order through common police court, a consent-type protective order, Mr. May will consent to that. And so that was part of the agreement in this case. Of course, he can't go do it. She's going to have to go down there and do it, and then he would consent to that.
Okay, all right. May 11th will be the next hearing date.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Allison Witt, case number CRB 2688.
Mr. DeWaters' case.
Your Honor, on this one, we're attempting to obtain video footage from Walmart, and we don't have that yet. This is a case that involves a Walmart incident.
Seems like we've had that problem in a few cases.
It happens occasionally. I don't know that you filed discovery, though.
I talked to the prosecutor's office about trying to obtain the video. I don't know that I formally did either.
And normally what happens is the discovery demand prompts our office to get the video. So
Let's
we
see
can
if I brought a formal demand with me. I can get a formal demand. If there's not one filed, Judge, I'll get a formal demand filed today.
Well, and also you can just tell Missy and she'll get it started.
Yes, sir.
Same date?
Yeah, that'd be
May
fine.
the 11th?
Yes, sir.
May the 11th will be the next hearing,
Is that okay?
10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Adam Scatt, case number PRC 26438 A and B, CRB 26449.
pretrial.
I think we're gonna have to look at both of them, but I'll be happy to at least look at it.
Your Honor, this young man's got a similar situation pending down in Ironton. That's scheduled for a pretrial in a couple of weeks. Just from a factual perspective, it appears, I think the state may agree with me that that case appears to be the better case. But Mr. Hill wants a chance to look at both of them and then try to make a determination about how to proceed. We don't have any objection to that. The one in Ironton, excuse me?
When's the other?
The one in Ironton? The 30th.
Of April?
Yes.
May 11th, then?
Well, yeah, that'd be fine.
That you're going to be here then?
Yes, sir.
May 11th will be the next pre-call, 10 o'clock.
Thank you, Your Honor. Okay, you want to write that down. Thank you, Your Honor.
Ohio versus Alexis McDonald, CRB 2616. The State of Ohio versus Alexander McDonald, case number CRB 25463. Mr. Holt and Mr. Morgan.
Alexis and Alexander. Mr. Holt.
Sorry, Your Honor.
Well, we found, yeah, Alexander, we've already got that. We've already got the warrant. Yeah.
Now, I see there's a motion about taking the dog. Is that hasn't been ruled on?
Has not, Your Honor. In fact, it was, I believe, set for today.
And do we know where Alexander is today?
He's out of town. He can't get off from work. He started a new job. He's on a 90-day probation thing. He can't call off or none of that stuff. So he said Fridays was better for him. That's what he told his lawyer. He said, I don't know. And I had work last week. That's why I couldn't make it. I couldn't get off my schedule. I'm short-staffed. I have 2 employees to my name managing down there.
Well, you had a warrant issued for not.
I understand, yeah. But my job kind of comes first. I could pay all these fines.
Mr. Hill.
Well, Your Honor, if it please the court, Alexis McDonald has 2 pending cases in which her, I believe the same dog has attacked 2 different people. She had a case in 2025, it was CRB 25161, in which she was found guilty of dogs running at large, and it involved an individual being bitten, and there was restitution, and there was an order for her to take the dog to animal obedience training, which has never been done. Now she's got 25 CRB 280, and I don't want to misstate this because there's one case in which the dog attacked a person and one in which the dog attacked another dog. And then Alexander McDonald, her significant other or husband, or I don't know their relationship, but they live in the same place and it involves the same dog, and he had a case in which the same dog bit a person. So we have 2 cases pending in which the dog bit a person and one in which it bit another dog. The dog has never been able to be picked up by the dog warden. Anytime that a dog bites a person, the dog is to be quarantined to determine whether there's rabies involved. Also, when a dog bites a person, there is raised the rebuttable presumption that that dog is a dangerous dog. And at that point, the dog warden has the authority to, and the discretion to impound that dog. And according to the prior law, there's new law as of March 20th, the prior law would have been that the person who owns the dog gets a notice that they can come to court and rebut the presumption that it's a dangerous dog. I think the law now is that the dog warden comes to the court first and asks permission, I believe. But anyway, these things all happened before the new law. The dog is still running loose now. On March the 9th, Ms. McDonald came to the court and she represented to the court that the dog had been moved out in the country where it wouldn't bother anybody. But on March the 16th, Deputy Frame sent us a video showing the dog still running around her property, loose, off the property. I've got a video of it. This dog needs to be picked up, quarantined, and at the discretion of the dog warden, it needs to be impounded pending final disposition in this case. It's still running loose, it's bitten people. Yeah, okay, so the victim on the first case that we have, which would be 25-280, has sent us another video, the dog running loose. So we're just asking for a court order for that dog to be picked up. And actually, there are two dogs. They have another dog. And ask for both of them to be impounded until we can sort this out, because it's just gone too far.
What's the position of the defendants with regard to the dogs being impounded?
Your Honor, there's never been anyone bit. I don't know where Mr. Hill's getting that.
We've got pictures.
Okay. If you check the case file, Your Honor, we entered a plea, and the restitution was only for the vet bill of another dog. That's what those 25 cases are over. Ms. McDonald, she can explain it, Your Honor, but she did inform me that she rehomed the dog at issue, which is Callie, is a German Shepherd that has been, that we did provide proof in the prior case was registered as a emotional support dog.
For my autistic son that's 14.
So they realized after the last case that was not, that she lives in the neighborhood. But both cases involved the German Shepherd. One was allegedly attacking another dog that was being walked. That was the first one. I think that was 161 by a neighbor. The second case was the dog entered which is the 280, entered the yard of another neighbor, and another neighbor shot Callie, the dog, because they had two puppies that were there. He said he was defending the other dog, or he was defending his two younger puppies. There's never been anything proven, or there's been no restitution about someone being bit.
She's never bit anybody, except for dogs.
I have, Mr. Hill showed me the first video. I haven't seen those, or haven't been produced in discovery. Ms. McDonald says that she has rehomed the dog.
And that, you guys can go to my mom's premises and see that.
What's the address and the name of your mother?
Melissa Brown, and then out by the Collins Career Center up past Getaway Church, up that gravel hill, the first house on the left, first house on the right.
You don't have an address?
I'll get it today and turn it into Holt.
So regardless of where the dog is at this point, it needs to be confiscated.
The second dog that's included in the motion, obviously, I recognize that she was not, she has multiple children, she works full-time. Her and Mr. McDonald are not together. They've been separated for some time.
About a year and a half.
So she understood that there was issues with the neighbors regarding German Shepherd, and she did inform me that she did rehome the dog, or attempt to. And the dog's still out at your mom's?
Yes.
She says the dog has, at least on one occasion, has came back to the house to see the kids, but that was...
She took her back because she got out of the yard, so she took her back to the house. But my 2-year-old was wanting to see her. He's attached to her, and pretty much they've grown up together, and he's about to be 3. She has been in his life the whole time, and she is very protective over him. I'm going to start getting videos myself, because their dogs are running loose in the neighborhood now, because my dogs ain't there. So they want my dogs gone, so the neighborhood can just be full of their dogs running around that get along, but I don't care. That's not right to me or my kids. That's why I removed my dog from the home, because I plan on selling my home, and then I plan on taking my dog back out in the country, but These
Well,
neighbors
it
gotta
sounds
realize
like
they've
we're
not
gonna
been the
have
right
to have
either.
an evidentiary hearing on this motion, and I don't know that either side ready to go forward with evidentiary today.
Mox is out, says he can have them.
What is that?
Mox is out, says they can have them.
There's a second dog that Miss McDonald says belongs to Mr. McDonald, so she doesn't, it's Mox, it's a mixed breed.
He's the one that was actually the last incident that happened. Callie wasn't doing anything, it shows in that video, which I would like that to be played, because she wasn't bothering anyone. She was far away from them. That showed me she grew a lot.
That was my question.
But then Mox, yes, he was in the
You
wrong
don't need to
spot.
say anything more. My question to the lawyers is, are you prepared for an evidentiary hearing today?
Well, we can't today. We've got 2 people who were bitten that we want them here. I guess really, if the court's not going to allow the dog to be impounded pending the disposition in this case, and we just like to have a trial as soon as possible.
Well, I can't just do it on your say-so. They're disputing the factual basis that you filed your motion for. So I have to hear the evidence. That's the way courts work. I have to hear the evidence and then make a ruling. So I can either do it on the motion, or we can just set it for trial pretty quickly and have the trial. Because it seems like it's going to be the very same evidence come either way, whether it's the motion to impound the animals or a violation of the statute. So let's just set it for trial. And we can do that. We don't have to even set it on a court day. We can set it on an off day if you're available to get it done quicker.
The next time I'm here, Your Honor, is May 8th.
Well, I just said we could do it on another day.
Okay.
I don't think we want to wait a month. I mean, there is new law which won't apply to this, but part of the seminar that I just attended a week or so ago, in the United States, one of the speakers showed 435 people killed in the United States over a 3-year period by dogs. And one of the top, number 3 breed, German Shepherd, 2/3 of them are pit bulls. 2/3 of the people killed in the United States are by pit bulls. And then divide up the other breeds. But I remember number 3 was German Shepherds. They're an aggressive breed too. So, not prejudging the case, but that is going to be part of the evidence, I take it. So, let's see. Let's get a date when we can come back. So I think we need at least a week probably to get the witnesses lined up and get them here. And this has to take precedence over, if you got to get off from work to come for a hearing, you got to get off to come to the hearing, man. And so does Alexander. He wants his interests presented.
Your Honor, I could do Monday afternoon, the 13th. I could move the hearing.
That's not going to be a good date for the court.
Okay. That's the only day that week I could do. I could do the morning of the 21st, Tuesday. Could move something there, pre-trial and custody.
That's probably okay. Let's see. I can do the morning of the 21st.
I can't, Judge.
Okay. Give me some dates. The 17th, we have 3 trials already scheduled for that day.
Would Thursday, the 23rd, work with you, Judge?
I'm in Athens County that day, Your Honor, all day. The 22nd, I could do the afternoon. I have a CLE scheduled, but I guess I could cancel that.
I could do
The
then.
22nd.
I'm good then, in the afternoon, Your Honor.
Afternoon,
Afternoon.
1:30.
Yes.
Mr. Hill?
Is this the trial, is this motion hearing, trial?
We're okay with that.
Okay, set it for a trial on the charges for April 22nd at 1:30.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. And in the intervening time, ma'am, I would just say, It is the law in the state, not always honored, but there is a leash law. If you have a dog, they're supposed to be on your property, and if they're off their property, they're supposed to be on a leash, not allowed to run loose. That is the law.
State of Ohio versus Brent Beverly, case number CRB 26187. This is set for arraignment.
Yes, sir.
Okay, so this is for arraignment today. And you're Sir Brent Beverly?
Yes, sir.
Mr. Beverly, the state's alleging that April the 4th in Fayette Township, you purposely tried to deprive Walmart of property without their consent. That's a theft charge. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand the rights you have as a defendant?
Yes.
How do you wish to plead to the charge?
Not guilty.
You want a lawyer appointed?
Yes.
Mr. Warford, I'll appoint you. Entering a not guilty plea. I do have a report from Lawrence County Recovery. He's been there since January, it looks like. So he was there when this allegedly occurred.
He's in our outpatient services, Your Honor.
Yeah, complete. You got paperwork.
Was he there by order of the court or on his own volition initially?
He was on his own.
All right, well, I'll make it a condition of his bond that he stay in treatment. He can sign a $1,000 OR bond. He has a bond up, I didn't see it. So he doesn't need an OR bond. He has posted a bond with Mr. Sowers, so that'll be continued. He will, I don't see he's been fingerprinted. Did he get fingerprinted?
Yes, Your Honor.
Okay. You have to be fingerprinted.
Yeah, they fingerprinted me at the jail.
Okay, it is in the file. I see it now. 27th or after, Mr. Wolford, for pretrial?
27th is fine, Judge.
April 27th will be pretrial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
No, I'll keep them, I'll give you a copy.
State of Ohio versus Colin Cox, case number TRC 26227 A and B. This is Mr. McCallum's case.
Mr. McCown's case, pretrial.
Thank you, Your Honor. Your Honor, we haven't had an opportunity to discuss it. The state has made an offer, so if I could get this one recalled in just a few minutes.
Okay, be recalled right in the document.
State of Ohio versus David Jones, case number TRC 252692, A, B, and C.
Mr. McCown's case, pre-trial.
Thank you, Your Honor. Your Honor, Mr. Hield has provided me today with an email purporting to be chain of custody statement from the trooper. That was the issue within the matter. It does not comport with my client's recollection of the events. And so what we're trying to do is go back. We need an opportunity to go back, try to cross-reference this with some body camera video. I've spoken to him about obtaining that. I'm not sure if what they gave us is the body cam at the hospital, where the trooper for the first time now alleges he specifically obtained the sample directly. And that's never been alleged before, so we just need a couple weeks if we could.
Okay, 27th?
That would be great, Your Honor.
April 27th will be the next hearing.
Thank you.
State of Ohio versus Terry Ray Snyder, case number TRC 26310, A and B.
Mr. McCown's case for pre-trial.
Yes, Your Honor, we've been, Your Honor, since the last pretrial, we have been provided with video discovery. There are some issues with the troopers, I think, analysis and administration of the SFSTs. I'm going to go through those with my client, and Mr. Hield has asked that I point those directly out, which I have no problem doing. So if we could put this out for 2 weeks, and I'll get him a memorandum as to what specifically we are objecting to, so that he can better assess it.
Well, I'm going to make it the 27th. You're here on that date anyway.
Okay.
April 27th. Pre-trial.
State of Ohio versus Robert Hill, case number CRB 26114, A and B. CRB 26335, this is Mr. Stratton's case, Your Honor.
Here's a co-defendant, Your Honor, Destiny Ricky Hill.
State of Ohio versus Destiny Ricky Hill, case number CRB 26103, A and B.
This is Mr. Smith's case.
It is, Judge.
Both of them do.
Your Honor, we have not been able to resolve this. This is a Walmart case. We'll need the video footage from Walmart. We both intend to file a request for discovery. If we could come back in the not too distant future, those are readily available usually.
Seems like there's been a little bit of
I haven't had one for a while, so maybe.
Yeah, it's just a matter of being asked for, and then we go to
Okay.
27th?
That's one of the dates I'm not here, Judge, 24th and 27th.
Okay.
I've also got some bad May dates as well.
Okay. What's good in May?
Well, the bad ones are 4, 8, and 15. Anything else is good.
About the first.
First is good.
First, yes, that'll work.
Is that good for you?
Yeah.
May 1st will be the next one.
One of those is for.
Your Honor, if I may, Mr. Hill has some community services to do on his post cases. He's not been there as ordered.
All right, Mr. Hill, when are you gonna get out to do some community service?
Well, about that, I've been trying. I've been having problems with my sugar and in and out of the hospital. And still haven't had my surgery yet. I go today for pre-op because they wouldn't do much surgery because my sugar's been running high. I go to Tuesday for pre-op surgery, May 13th.
Okay, well, if you think you're medically unable to do it, you need to bring something in, and the other option is, let's see what your entry says.
I mean, I can come do it regardless. But just like I said, blood sugar's been messing me up.
Oh, 700s, okay.
Up in the 700s.
Just give it medical. Doctor, this.
Yeah, you got a 10-day jail sentence suspended, so if you can't do the community service, you'll have to do the jail time.
I'll do your community service, sir.
Okay. Get it done.
All right, we're good.
All right, so next hearing is May 1st.
State of Ohio versus Roger Burris, case number CRB 26165. Your Honor, this was set for pre-trial today, but he has been picked up by the adult parole authority on a parole violation, and he's on his way to prison.
And this was your case, Mr. Stratton? I
Yes,
believe.
yes, the state indicated, I'm not sure what the state's going to do exactly on this case, whether they're going to ask for a warrant or dismiss it.
So domestic, yeah, it is a domestic violence.
In a closer reading of the affidavit by the officer, by the narrative statement, it is indicated that it sounded mostly like threats and pushing around and no injury, but in speaking with the alleged victim, she says she went to the hospital emergency room with a neck injury. So that does lend itself to the potential of this being a felony because of the prior. And so I wanted to so we're going to nollie this to the grand jury.
Okay. All right, the case will be, he's in custody anyway. It'll be nollied to the grand jury, and then they can decide if they want to up the ante there and charge him with a felony rather than a misdemeanor. So here it'll be nollied.
State of Ohio versus Devin Humphrey, case number CRB 25618. That's David.
Yeah, David.
It's Mr. Stratton's case after pre-trial.
Sean, who is this? I'm sorry.
David Humphrey. Got a letter here for you. Yes.
Is this my copy?
Yes. Oh, do you?
Yes.
Okay.
What's the state's position on this going forward?
So far, he's done exactly what we hoped he would do. It sounds like he's doing well. Is Mr. Ernie Humphrey here?
No.
And we haven't heard anything back from him. Make sure.
No, we haven't heard. He actually dismissed the TPO. Not even wanting conviction. And I told him to call me if there's been any problems. I've never heard from him in a long time.
Your Honor, we've been at this for quite some time at this point, and at an earlier hearing and also in communications with our office, Mr. Ernie Humphrey has indicated that what he wants is for David to do well with PATH, and it appears that he's accomplished some things for himself. And the last time we were here on February the 6th, we indicated that we would be looking at dismissal or asking for dismissal, another good report. And I didn't read the whole report, but what I read sounded positive. So we're good with going ahead and dismissing today, Your Honor.
Case will be nominated.
All right. Thank you.
Congratulations, Mr. Humphrey.
Thank you, sir.
Case is dismissed.
State of Ohio versus Christopher McBride, case number TRC 26168, A and B.
Your Honor, last time we were here, prosecutor didn't have the video and narrative. They do now have that. I don't have that yet, so I'll request that from them, and then we'll go from there.
Yeah, the traffic stop in this case was initiated by a South Point police officer, and we requested a written narrative statement of what happened, and we've received that. And also, we also have the trooper who followed up and completed the investigation. We have his video
Yes.
available as well. So,
Is there other video to be had that we don't have?
No, I think the state now has everything,
Okay.
so I just need to
Just
get
a matter
it.
of getting it to you.
Yeah.
Well, we're probably in the May. What's your schedule on May?
The 11th and 18th are bad.
4th or 8th? 8th is Friday.
8th will be fine.
May the 8th for the next hearing. 3 o'clock, 10 o'clock.
They hurt me for the day. This much, I'm working a hard day. Days after down there, I know who these people are.
Okay. Once I get this, I'll let you know. Bye.
State of Ohio versus Cody Kelly, case number CRA 26110, CRA 26109, CRB 25542, A and B, CRC 252252, A and B.
Your Honor, this was the case we had reset from Friday.
Right.
Mr. Kelly's at TCC. Also has an ankle monitor, which we talked about removing today.
Right.
That's the one we gave the grand jury to Jack, because you had it brought down.
oh, this is the two.
Yes.
We're gonna talk about that, because that was,
Because I thought he said it, that they was keeping mine, because he had more something like this.
yes.
Because she's got the files. Okay, Judge.
Okay.
When the Davis one was not to the grand jury, you told me to go ahead and bring this.
Okay, that's fine.
Now that for them to adopt at the same time.
So what do we have pending here?
That
Oh, it's
case.
still pending here.
Yeah.
This was the case with the two felonies we had, we were talking about keeping him.
I found out what happened.
Okay.
Well, we took his file, along with the other file, because we were going to indict them both. So,
Must have been indicted.
But we were talking about Mr. David Hill here.
well, I know. Let's see, did you click the? Okay. Oh, this is the old cases. Let's see. All right.
Sorry.
I'll look here.
We've got 2 felonies pending that are still here, then it's my understanding there's one or 2 that have already been sent to the grand jury, or what happened?
Well, what happened is, and this is just my mistake, John Davis is a co-defendant, and they're both alleged to have stolen the same 2 cars. John Davis's case has already been disposed of here by being sent to the grand jury. At that time, I made the decision that, well, we'll just take both of the cases and we put Mr. Kelly's file with Mr. Davis's file to go to the grand jury. I don't know why I did that at the time, but the idea was that they would both be indicted. But we've been back here since then. So his case is still pending here. It was my prior decision to take the case to the grand jury. But I also know that there might be some differences between Mr. Davis and Mr. Kelly as far as their histories. And that maybe there would be, and Mr. Stratton's done a very good job at urging me to keep Mr. Kelly's case here. So I haven't made a final decision on that, and we have a little bit of time before the next grand jury. So we want to see Mr. Kelly continue to do what he needs to do in treatment, and I'm not making any promises today, but I'm considering the idea of keeping those cases here, not to just be dismissed in the end, but at least not going to the grand jury. So if we could...
So are the theft cases here now? And
the theft cases...
26110 and 26109 are felonies, right?
Yes, those are the same as the 2 that Mr. Davis had that went...
Okay. All right. And he's got some older case from 25. And those 25-542 are still pending. That's obstructing.
Obstructing or resisting, I believe.
Okay. And then there's an OBI.
That he's had, I believe he's already pled to that.
I'm pretty sure of that.
Yes.
I'm not.
No, it's not set for a pretrial.
He just hadn't been sentenced.
Yes.
There's no judgment entry.
I could start paying on some of them fines whenever I get farther along in the program.
Okay. Well, you got a good report. So here's where we are. You got a couple felonies that they could take to the grand jury, indict you on, and then you'd be down at the main courthouse in the felony court. If you get a conviction, those judges can send you to prison.
Yes, sir.
As long as you stay here in this court, you got a felony, but even if you plead or something on it, they'll have to reduce it to a misdemeanor, and you won't go to prison. There's no way you can go to prison from this court.
That's my plan, sir. I'm trying to be there for my son and trying to change my life around.
Okay, well, you're getting a chance to do it.
Yes, sir.
The proof is going to be in how you perform. So I'm going to order the ankle monitor taken off.
Thank you so much.
So a lot of people skip out when that happens. So if you do that, you're going to guarantee then that these felonies that are laying here, they're not going to be beyond my control.
I know.
They're going to say, Judge, we want to take it to the grand jury. You're going to go down to the common police court then.
Yes, sir.
And whenever you get caught, you'll be facing possible prison time, not staying here with me. You'll be out of my control.
Yes, sir.
You understand that?
Yes, sir, I do.
Okay, so it's up to you. Ball's in your court, as they
Yes, sir.
say. If you want to, the better you do in treatment, I think the better the result's going to be legally and personally.
Okay,
Legally, you'll get the best sentence if you do really well in treatment, and I'm convinced you stay here that you're sincere and you want to stay in recovery, be a good father, and contributing member of society. And if you mess up, you're gonna go down there and you'll have to sell it to whatever you're doing. It'll be a totally different judge. And
Yes,
you'll
sir.
have to sell whatever you want to see happen to you. So that's what I want to see. I want to be convinced that Cody Kelly is going to be a good member of our community. How old's your son?
He's 5 years old.
Okay, so that's really impressionable age, and you need to get with it, being a good dad to him.
Yes, sir, I do.
Because you want him to turn out and have a good life.
Yes, sir, I do.
Okay, and we know from statistics that if you keep using, the chances that he's going to grow up and be a substance abuser go up.
Yes, sir.
So if you want that to happen to him, keep doing it yourself, because he's going to follow in your footsteps.
Yes, sir.
He may not, he may totally reject it and go the other way, but the odds are he's going to follow you.
Yes, sir.
Really. So I don't know if it was portrayed to you as a kid, but now's the chance to break the chain. If people were doing it and you followed them, let's break that chain and set a different example for your son.
Definitely was a follower whenever I was younger.
Okay, so you know, you're old enough now, grown man, you know what you need to do.
Yes, sir.
You just gotta do it.
Yes, sir.
Okay, so there's the end of the sermon. Let's come back at some point and I'm gonna find out, because we're taking the ankle monitor off. I'll order that today, and then we'll see how you do. Let's come back around in the 1st of May sometime.
Okay.
4th?
Yes.
Is that good? May 4th is going to be your next hearing. Look forward to seeing you with a good report. You've already come a long way, I can tell just by your presentation over what you were when you first started coming in here.
Yes, sir. I understand.
Yeah, I mean it. You look good. It takes a while though to recover. You know, the people that are really experts in this, it's not a matter of flipping a light switch. Your brain takes a while to heal up.
I'm currently coming off Suboxone while I'm up there too. I'm just coming off everything.
Okay. Good plan. Let's make it work.
Yes, sir.
See you on May the 4th.
All right, thank you. Do I go to the courthouse, or do I go to home confinement now?
Go see Mr. Major and he's gonna set up for you getting the monitor off, and then it's up to the counseling center. They're in charge of your treatment.
Yeah, he's out there. All right. Thank you, sir.
You're welcome.
State of Ohio versus Jeremiah Gerald, case number TRC 26382, A to B.
Case set for pretrial.
It is, Judge, I filed discovery last week. It's not yet been answered. I would ask we come back in a couple of weeks. I don't think it'll take very long to answer. The 24th and 27th are
Bad days.
in April, yes. And I've got some May bad dates also.
Well, we could do the 17th, right? That
Yep.
date, so that should be enough.
You should be, I filed it last week. That should be enough to get, I would assume. Good for you. 11 days.
April 17th,
April
which is next year.
This is the first offense. You gotta go 45 days and then you get 30 days. I'll talk to you. 17th at 10 o'clock.
State of Ohio versus Rebecca Ventura, case number TRC 2689,
Yeah.
A to B.
Mr. Smith's case, pretrial.
He withdrew as my counsel, even though the last time you and I spoke,
I didn't say,
I filed a motion, Judge. I'm willing, she can either self-represent, hire counsel, or I would withdraw the motion if she wants me to. But
I do wish for that.
Okay, well, let's do that,
Absolutely.
Judge, and let's get a date.
Okay, so the motion to withdraw is counsel.
Could we use that 17th date? Is that
And
a bad day, or?
for a trial, or?
Oh, no, pretrial, like I said, for a
Pretrial.
pretrial. Yes, pretrial. I'm sorry.
And you're agreeable with that, ma'am?
Yes, please,
The
yes.
17th
And
for a pretrial at 10 o'clock.
I'll get you before 17th. Yeah, we'll talk. Good.
all right, so the 17th?
April 17th.
Yes. 10 o'clock.
We need a time waiver.
I'll sign time waiver, Judge.
4/17.
State of Ohio versus Kevin Dale, case number CRB 24681.
This is Mr. Morford's case.
There's a copy of there, just you still got a hard hat. That's good.
Yes.
And the witness. Thank you.
Said knowledge of grand
So
jury.
get a report and get screened.
Go straight, because you can't do a knowledge of grand jury injury away from the school. because
Carry on, Judge.
Computer system, like pensions.
Yes,
So once
he's
you
not,
fill it in,
it doesn't look like he's finished
it has
That's
yet.
to be streamlined.
fine, but we still want to take it to the grand jury, even though we don't have it that way.
Well, they can't have it in the computer. It won't
That's
let us
fine,
do it.
that's fine. That doesn't mean we can't take it.
No, that's not what they're saying. They gotta redo the injury. They were just saying, he can't do this injury.
That's
Because
fine.
the
At the age?
computer system wants to take it.
That's good.
Because it's spitting back out.
At age.
As long as the file just get filed.
No, no, sir, I was telling you, we gotta do the injury, because they can't get it.
Just look to it, know what they got in the witness.
State of Ohio versus Bradley Williams, case number CRB 26148. Your Honor, according to the information from the Williams is currently at the mental health center.
Okay. This was Mr. Morford's case. So he has been admitted to Appalachian Behavioral Health. So we want to just monitor periodically.
Yes, Judge.
th 2 weeks. April 20th will be the next hearing.
Thank you, Judge.
State of Ohio versus Terry Hager, case number TRC 26383. Terry Hager.
Terry Hager, set for pretrial, has a bond up to Mr. Sellers. He told me he's going to hire a lawyer, but no one's entered an appearance. Terry Hager's been called for, has not appeared. Notify Mr. Sellers of the failure to appear by text.
she's on probation with a person didn't get bail. I know Kim keeps on taking bail. She gets scratched. It's a serious.
Probation violation for her.
And why does he keep on saying that she didn't get bail? She just didn't have to get medical treatment. It's a stress. It got her dog. And got her dog. That got her dog better than her. You know what I mean? It's just service discretion. So why does he keep on saying that? Just because we don't have medical, I told him before.
You know, here's the thing. 4 cases involving the same dog at the same time. That should be bad enough.
So bond forfeiture,
John's got to do it. Okay, I'll do it.
27th, April 27th.
State of Ohio versus Christopher Conwell, case number CRB 2693, CRB 25597. Your Honor, the clerks have tried on numerous occasions to reach Mount Carmel, where this person is, and have left messages. I don't know.
That was him on there.
There was an appearance on the screen from, it said Samsung, and there was no indication of who it was. It was on the screen, and all of a sudden it disappeared.
I believe that was for Christopher Cornwell. He's at Mount Carmel.
Yeah.
That was him up there for the longest time.
His mother tried to contact him.
And his mom's outside still trying to contact Mount Carmel. But that was him on the screen up there under the Samsung name for the longest time, and then when we walked in, it disconnected, so.
Ryan and I also attempted several times over the weekend to get a hold of someone there to set this up too.
He was admitted, but that's really all it says, so I don't know.
That's all we know.
Is there
He's there, his mom says.
him, what they're going to do? Let's keep trying to get further information. And
Yeah, if we roll it off to the next court date.
if we can't today, then I'll set it for another day. They had called this morning, and we can give them a known time, because I know they get upset apparently on having to wait. We can say like at noon or 11 or something. Just when the court first starts and they show up, I mean, there's so much going on, it's hard to break in and get them in.
Yeah, we didn't realize that was him until I walked in, realized it was him, and as soon as I walked in, it disconnected, so.
Okay. All right, so I'm going to put it aside and we'll deal with it later. If we can't, if not, I'll set another day.
All right.
Thank you.
State of Ohio versus Harrison Letchford, case number TRC 26222 A and B, CRA 2681. Harrison Letchford.
It's Mr. McCown's case, one there, and pre-trial.
We have pressure on it.
Yeah.
They're in their own table. Haven't even made it back yet. Keep getting here.
Your Honor, it's my understanding that due to some evidentiary and some factual issues in this case, that the state is willing to dismiss with prejudice the felony charge and the criminal refusal charge. In exchange, Mr. Letchford would enter a plea of no contest with a stipulation of finding of guilt to a low-end first offense OBI.
Is that correct, Mr. Letchford?
Yes, Your Honor.
You have a right to make a statement to the court. Do you have any statement you want to make before sentencing?
No, Your Honor.
Okay. All right, so 2681, CRA 2681 is dismissed. There's the sentencing on 26222. And was there any damage to anybody else's property?
No, Your Honor, it was in a ditch when we had the snowfall.
Okay.
So,
All right, so then on the OBI, you treat it as a first, it was a guilty plea.
no contest, Your Honor.
No contest with finding of guilt. So I'll set a $400 fine, order the cost be paid, 6-month license suspension, started the day of the incident, February 6th of this year. 20 days in jail, all suspended on the condition there's 5 days of community service performed, 2 years of level 4 probation. Got to go to the DIP school, the Driver Intervention Program. 30 hours of community service, I didn't already say that. Review hearing October 5th this year. And a $20 fine on failure control.
Judge, we didn't discuss this, but can he get occupational privileges
Yes.
and medical, et cetera, all those limited?
You can have a permit for work, community service, medical. Anything else?
I think that's it, Your Honor.
Okay. You'll need to see Mr. Major for that and see him for going over his probation terms and getting a copy of the entry.
Thank you, Your Honor.
You're welcome.
Your Honor, we're ready to call some Lawrence County Jail inmates who are back in hold.
Okay. We have inmates here in person to deal with, so we'll start some of those.
State of Ohio versus Alicia Bent, case number CRB 26185.
This is for arraignment.
They set up this ship. This is
And ma'am, are you Alicia Van Luna? Am I pronouncing that correctly?
No,
Okay, help me.
Alicia.
Alicia, so the last name I got right, that's the one I was worried about. All right, Ms. Van Luna, it's alleged, well, let me explain your rights to you first. You have a right to remain silent, you don't have to say anything. You do make statements, it's on the record, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio prove the charges filed against you beyond a reasonable doubt. Do you understand this then? The charge against you, staff, the state's alleging that on April the 5th in Fayette Township at the Walmart there in South Point, that you tried to deprive them of services or products without paying for them. So that's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge? How do you wish to plead to this charge? You can plead guilty, not guilty, or no contest. You got to pick one of those three. And if you're not sure, not guilty is the safest plea to enter. So what plea? Well, if you don't know, I'm going to enter a not guilty plea for you. So, do you want to be considered for a court appointed lawyer? Do you have a job? What do you do?
Do medical records.
Where do you do that? VA hospital? Are you paid? I have to determine your gross annual income. You know what that is? What do you make in a year, gross? You get paid by the hour? How are you paid? Or a salary?
I think I might be like 35.
An hour?
35,000.
Oh, 35,000. Okay. That's your gross income? Do you have children? You're a single person? Okay. Well, you're going to have to hire a lawyer then, because you make too much money for me to appoint a lawyer for you. So, and I see that you, well, the address I have is at Auburn Road, Huntington. I don't think they spell it right, but there is an Auburn Road in Huntington, I know that, so it doesn't have an O in it.
We move to amend that
I'll
to
strike
a U.
the O. It should be A-U, not an A-O. Okay. Is that your correct address, is 2950 Auburn Road? Can you post a bond? If I give you a bond to post to guarantee your appearance, and what that means is, if you don't show up, then the bail bondsman will come get you and take you to court, or actually take you to jail, but make sure you come to court, because you're out of state. So I want some kind of guarantee that you're going to be here. So $150 to $200, you think you could post a bond like that? Well, yeah, today would be preferable. You're the one who wants to get out of jail. Everybody wants out of jail immediately, if not sooner. If you post it, you can get out today. Do you have access to any money? I mean, you got a bank account somewhere? You don't have a bank account? You're working at the VA making $35,000 a year and you don't have a bank account?
I have no idea if there's nothing
There's not, okay. Do you have family, are you from Huntington?
in. Yeah.
You got family over there? Okay, well, you think one of them would post your bond for you?
I don't think they can afford it.
Okay. Well, I don't want you to sit in jail, but I want some kind of guarantee that you're going to come back and you're out of state. And I think a minimal bond would have to be $1,500. So if you got $1,500, you can post the $1,500 with the clerk, and you get it all back at the end of your case as long as you came to court when you're ordered to. If you can't post the $1,500, you can hire a bail bondsman. They're on the hook for $1,500 if you don't show up, and then you'll pay them a fee. Usually it's 10%, so $150 probably gets you out. But then if you don't show up, they're going to come track you down, nab you, take you to the jail for not showing up. So do you want to talk to the bail bondsman? I think you do unless you want to just sit in jail. You prefer to get out. Everybody does. I don't think I've had anybody say, I'm fine sitting right here. Everybody wants out of jail. But if you don't get out, I'm going to set you for a hearing pretty quick. Let's do it for next Monday, April the 13th. So if you postpone, you got to be here. You know where you are. You're in Chesapeake, about a mile from the 6th Street Bridge. Okay, you got to be back here next Monday at 10 a.m. Put down you will hire an attorney. Not guilty plea is entered for you, and you'll let Mr. Sowards know. Okay, you should be hearing from the bail bondsman. He'll probably call the jail. He's going to come here. He's going to come here? Okay. You'll hear from him one way or the other. Okay. That's all.
Yes, I put it on his stuff. Yes, I'll have their twice.
State of Ohio versus Colin Hoffer. Case number CRB 26-186.
Because I've been out there twice and I saw him. I went in and made for sure. We'll call him. See. Well, let me see if they're still there.
So you're calling Lee Coffer?
Yes, sir.
Mr. Coffer, it's alleged that in Union Township, April 3rd, you knowingly caused or tried to cause physical harm to Sierra Ratliff. That Sierra is either a member of your household or lives in your, or a member of your family. So that's a domestic violence charge that's been filed against you. Maximum penalty for it, 6 months in jail, $1,000 fine. You have a right to remain silent. You don't have to say anything, but what you do say is on the record. It can be used against you. You have a right to have an attorney, to have one appointed. If you can't afford one, to have bail. And make the state of Ohio prove the charge against you beyond a reasonable doubt. You understand those things? Yes, sir. How do you plead with this charge?
I'd like to get a court-appointed attorney.
Okay, I'll enter a not guilty plea for you then. Do you have a job?
At the moment I started treatment, it's supposed to start today. Restoring hope.
Where were you going to go to treatment?
Restoring hope. I'm already enrolled, I already did my assessment.
Mr. Smith, I'll appoint you.
Sierra Ratliff.
What's the state's position on the bond? Mr. Hill, what's the state's position on bond?
Well, I'd like to know if he really is going to Restoring Hope. That might make a difference. Our primary concern is going to be making sure that there's no contact between him and Sierra Ratliff pending further determination of what's going on. So if he's going to Restoring Hope, then we're okay with no R bond with the protection order.
He says he is, of course, I have no confirmation, I just met him, he says.
Is there anybody here from Restoring Hope?
Her name is Shannon. I've got to prove her on it when we come back to court in 2 days.
Well, I'd rather use somebody that's here at the court.
Anybody you know Restoring Hope could call and check.
Do you have a Ohio medical card?
Yes. Okay.
They have. Yeah, several. Thinking of a number between 1 and 10. Michael? Yes, sir. Number between 1 and 10. 1.
4.
Okay, you two are going to have to think of another one because you're over 5. Okay.
3.
7, so it's hometown. Hometown's gonna assess you. They're a trusted provider, they're here, they have people here giving me reports, restoring hope. I'm not gonna say dispiriting, but they're not here that much, so. I want somebody who's gonna be here and will give me reports as to what you're doing. So, let's get that done today, and then, we'll come back after you've been assessed, so we'll recall. We'll do it in the back, she'll talk to you back there.
State of Ohio versus Christopher Conwell, case number CRB 2693, CRB 25597, CRB 25540, A and B. Your Honor, I believe that should be someone on Zoom, not Conwell.
That should be him.
Okay, is Christopher there?
That's his phone. I don't know what's going on.
Chris, you need to unmute your phone.
Can't see him.
There we go.
There he is, okay. And
Yeah,
there,
that's what I mean, I don't want everybody to freak out, or they're thinking,
I don't know.
I don't understand what he said, I don't want to freak out, but,
oh,
so, you're at Mount Carmel East, correct?
No, now Carl became your old house.
Okay. Is he going to be allowed to stay there for a while? What's his status?
no, sir.
This is Patty with social worker. He will be here for a few more days.
Sure.
Well, we don't know that for sure right now. The plan is to discharge him back to TCC if that's where Chris wants to go back to.
Yes, sir.
But as of right now, I don't know what discharging.
I got that, that's what I know.
As of right now, I don't have a discharge date for him to get out of here yet.
Okay.
It was for 30 days, sir, that's it.
Okay, so put it on the docket on Friday, we should have a better idea then.
Yes.
Yes, sir.
I'm sorry?
Yeah, Friday.
So if he's still there, I'd like to see him, and we could set it at a particular time so that you don't have to sit around waiting. We can make it, let's make it 11:30, like it is right now. If he's already
On Friday?
on Friday, if he's already at the counseling center, then they'll give me a report as to his status. But that way I can just make sure where he is.
This place typically
Okay.
takes up to 10 days.
We can do Friday at 11:30, same Zoom link.
Yes,
Yes.
thank you.
Okay,
Thank you very much.
we can do that.
Thank
Thank
you
you.
so much.
Okay, so April 10th at 11:30.
Yes.
Okay.
Yeah, that's all it is, sir. That's how I am. I feel like I didn't need her to be like, I got schizophrenia that day. That's what
Are we all set, Your Honor?
We are all set.
Thank you so much.
Thank you.
Thank you.
Yes, sir. I did pull.
State of Ohio versus Jacob Skeltner, case number CRA 25146, who's back in Holden.
Yes.
I mean, he's only like 18. It's not.
All right, and Mr. Holt is the attorney on this, but I don't know, did he stick around or
I
not?
think he's already gone there.
Okay. She was here last fall and was ordered to Bethesda, in my notes where she left Bethesda or never went to Bethesda, I don't know. I understand, I've been informed she went to another facility and has been arrested on a warrant at somewhere out of county today. Or, well, before today, but recently. And I've got email in the file. Okay, well, that's not from a treatment provider. It's just from somebody that knows her. Well, your attorney's not here today. I think you probably didn't know you were going to do. This is on an F3 theft of a firearm. Are we sure, was there a warrant issued from here, or did it go to the grand jury?
At the time, back on October the 6th, 2025, my notes indicated that we didn't know for sure if she'd left treatment or not, because my note says if she left treatment, then this is a grand jury case. So I don't know whether we knew or whether it was resolved or at the time, or whether a warrant was issued or not.
Well, I've got BW bench warrant, left treatment at Bethesda.
Okay. All right. So, well, we probably will take the case to the grand jury, but our lawyer's not here. This complicates things. So I guess if we reset the case maybe for Friday, and
What's the state's position on bond?
we want,
There was also, I believe, a warrant out of another county. Was there Knox County or? Okay, so you got a record of that also. So it may be academic, because I think she's got an order from another county, but what would the state's position be on bond now?
what was the bond previously, Your Honor?
2,000 OR, because she was going to go to treatment at
Okay.
Bethesda.
Well, we'd ask for a $5,000 cash assurance bond.
Okay, I'll set bond at 5,000 cash or surety, put it on the docket for this Friday. And I'll notify Mr. Holt that she is in custody. So it'll be a preliminary hearing scheduled for Friday at 10 o'clock. Okay, that's all.
State of Ohio versus Adria Price, case number CRA 26190. And case State of Ohio versus Vicky Price, case number CRB 26173 A and B, CRB 2628, CRB 2689.
These are all Vicky's, this is theirs.
And none of the cases are still up.
They're all theirs.
Fire cases?
Oh, no, 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 all those are done.
Okay, let's see.
They, see, they can really do anything more with them, but they're not.
Okay, we just have them all here.
No, those are all the new charges.
They are in different files?
Yeah, because we done had a trickling.